On March 12, 2010, a single sheet of paper changed the geometry of my life. I still carry that page. It is folded so many times its creases have become part of its anatomy, a map of the hands that opened and closed it over years. The edges are brittle, ink-feathered in places, and someone, probably me, in a moment when facts needed to be tangible, wrote notes in the margins in a hand that trembled when it needed to be steady. Sometimes it sits in my jacket, a physical talisman against the fog of memory. It is both evidence and compass, a blunt instrument that finally named what our quiet family arrangements had rendered into arithmetic, and a guide that pointed toward accountability. The wound the paper represented began long before I understood probate law. As a child, a single house defined what worlds were possible. That house was the center of summers and punishments, of dishes and small mercies. It was the geography of an ordinary life. Then, in a small, precise moment, I was told, first implicitly, then explicitly, that my presence in that house was conditional. Phrases like "for your own good," "family fairness," and "we must think of the future" dressed the rules as affection. Beneath them, however, lay a ledger mentality that could be written as law. Childhood exile lodged inside me privately for years until that damp March morning in 2010, when the folded page made the ledger audible. I remember the morning with a clarity that still surprises me. It had rained, courthouse steps were dark and slow to dry. We met in a small coffee shop tucked into the complex, a place where litigants waited and lawyers took quick breaks between calendars. She arrived without fanfare, coat worn by long commutes, a manila folder with softened corners. The lawyer who would become my collaborator and teacher sat across the table, drank black coffee, and watched me without rushing. She had a habit of being quiet when quiet mattered. "You should see this," she said. Those 3 words, spoken in a courtroom coffee shop, shifted the geometry of my life. What she handed me looked ordinary, a codicil disguised as an afterthought, a single paragraph of legal housekeeping that operated like an ultimatum. It encoded a presumptive condition: living arrangements and inheritance would remain as written unless some vague line was crossed. The clause cast a child as forfeitable rather than a person with rights. In that moment I understood that a will could be not only instruction but threat, an instrument that made belonging contingent on compliance. Over the next months and years, 2010 into 2011, the lawyer taught me to read a file the way an archaeologist reads strata. We sat across conference tables in legal aid offices and in the cramped back rooms of the nonprofit clinic she helped build. She showed me how to parse signatures, the angle of a pen, the shallow pressure of a troubled hand, the way an autograph might be rushed at the end of a visit. She pointed out witnesses' names added suddenly, notarizations completed hurriedly in corridors, bank disbursements timed to match last-minute changes. Her vocabulary, undue influence, vulnerability indicators, chain of custody, sounded forbidding at first, but she translated jargon into everyday acts I knew intimately, visits that always ended with favors requested, a drawer in the kitchen never locked, offhand remarks that accrued leverage like interest. Private humiliation became evidence that could be argued in court. That translation mattered because it converted grief into something usable. Therapy and confession have their place, but this was forensic, a way to name coercion and hold it up to the light. I learned that documents are not neutral, they are political artifacts. A will's apparent even-handedness can mask pressure sustained over years. Once that reality became visible, advocacy ceased to be abstract moralizing and became methodical work. We began cautiously. Late in 2010, the lawyer donated pro bono hours to a tiny nonprofit clinic cobbled together with volunteers and leftover grant money. In early 2011, the clinic formally launched. We called no press conferences. We trained a handful of volunteers in preservation, how to photograph brittle pages without smearing ink, how to note the presence or absence of initials, how to transcribe voicemail messages with timestamps. In 2012 we built chain of custody templates, documents that sounded dull and bureaucratic until they proved to be the vertebrae of a case. Photography grew into ritual. Volunteers learned to balance a camera to reveal watermarks and to capture the subtle pressure of a signature. They were taught to spot margin notes that indicated later edits and to look, as the lawyer liked to say, for little acts that mean everything. We trained them to create contemporaneous records of conversations, who was present, the tone of a remark, the context, because in probate as in life, Context is often the pivot point. We photograph things that looked irrelevant until they were not: a date in a different ink, a grocery receipt that aligned with a withdrawal, a hotel keycard with a timestamp proving a visit occurred during a supposed moment of solitude. The work had no glamour. It was patient, methodical, and painstaking. Courts understand a ledger. They understand paper when it is carefully documented. Those technical practices yielded cumulative victories. From 2011 through 2014, we began to secure what felt like small triumphs. Documents admitted that had previously been excluded, temporary restraining orders permitting access to funds for therapy while an estate dispute played out, evidentiary hearings that recognized patterns of undue influence rather than isolated acts. Each victory looked modest on its own: a motion granted here, a judge's memorandum there, but together they rerouted probate practice. Judges issued opinions that explicitly referenced economic leverage as a factor in undue influence. Guardians ad litem were appointed who had training in family coercion rather than merely reputations for competence. Those granular rulings changed lives in measurable ways: a child able to attend therapy, a temporary fiduciary appointed to preserve assets, a probate clerk asking a single-pointed question at intake. Law lives in the friction between evidence and politics. From 2015 onward, our litigation and policy proposals drew attention, and with it, sharper opposition. Those who had once dismissed us as meddlers framed their critique around constitutional values: testamentary freedom, individual autonomy, slippery slopes. Editorialists argued that even narrow limits on wills threatened liberty. Their rhetoric was elegant and abstract. It ignored painted stoops where 11-year-olds sometimes stood and asked if their existence had become a line item in a ledger. We adapted. Beginning in 2013 and intensifying in 2015, we built evidentiary portfolios pairing individual stories with hard data. We commissioned cost analyses linking adolescent homelessness to later public expense and compiled demographic research showing correlations between housing instability in the teen years and higher dropout rates, lower lifetime earnings, and greater criminal justice contact. We gathered social worker interviews documenting how inheritance clauses had redirected healthcare access and housing decisions. Our case studies showed that modest emergency funds for counseling or transportation often kept teenagers in school and out of cycles of homelessness. Emotion can move hearts. Data forces opponents to answer concrete questions about trade-offs and consequences. Our legislative campaign moved with the deliberate pace lawmaking demands. In 2015, we convened a coalition that included elder law advocates, child welfare organizations, legal aid groups, and social workers. We drafted bills that did not abolish testamentary freedom but created discrete tools within probate practice to address coercion: expedited access to emergency funds for dependents, mandatory training for court staff to identify indicators of coercion, authority for social workers to petition for temporary guardianships when a child's access to housing or funds was contingent on a will's terms. We aimed for practical levers judges and clerks could use in the midst of messy family arrangements. Hearings stretched into months. Committee rooms in 2016 and 2017 became familiar arenas. I testified in those rooms, sometimes with spreadsheets, sometimes alongside siblings whose kitchen table memories made technical statutes immediate. We argued repeatedly that narrow reforms, procedural checks, training programs, emergency fund mechanisms, would preserve both elder autonomy and child safety. The lawyer who had first shown me the clause insisted on incrementalism. She had watched ambitious reforms die when implementation proved infeasible. Her caution was at times frustrating. In 2014, I wanted sweeping change. She was right. Reforms that clerks could paraphrase and social workers could cite were more likely to survive politics and turnover. In the fall of 2018, after 3 years of testimony, drafting, and coalition work, a package of modest statutory reforms passed in our state legislature. The statutes did not dominate front pages. They were technical: provisions for emergency funds, continuing education requirements for guardians ad litem, protocols authorizing neutral fiduciaries when family relationships looked weaponized. But they mattered. They permitted social workers to seek immediate relief to keep a child in school while a will challenge proceeded. They created an expectation that probate staff would flag suspicious conditions affecting dependents. And they authorized courts to place assets under neutral management while evidence was gathered. The benefits were immediate and quietly profound. In 2019, a case manager used our template memo to secure emergency counseling for a teenager who had been told she would lose access to a mother's house unless she relinquished custody of an infant relative. The memo cited the new statute, supplied trained observations from a social worker, and referenced a short body of supporting case law. The court granted emergency relief. The teenager stayed in school and received therapy. Months later, she testified at a committee hearing, speaking without theatrics but with a clarity born of being seen and supported during acute vulnerability. Other victories never reached headlines. In 2016, a mid-sized county judge reversed a routine acceptance of a will after our evidence clerk uncovered a pattern, a series of bank withdrawals traced to a beneficiary who also appeared as a witness. The judge's order was technical, based on timing, absence of independent witnesses, and transactional ties, but human in effect. A neutral fiduciary was appointed for interim management. A child who had missed months of medical care received consistent treatment. That case did not make front pages, but it altered a life in a way statistics cannot fully capture. Coalition building required listening and compromise. Between 2015 and 2017, we sat in dozens of rooms, legislative backrooms, elder law bar sessions, church basements, and school counselor trainings. People came with different priorities. Elder advocacy groups worried about procedural burdens on older clients. Child welfare organizations pushed for more robust remedies. Some advocated criminal penalties for obvious coercion. Others wanted preventive social services to reduce the conditions that create vulnerability. We negotiated language, refined definitions, and agreed on implementable interventions. Ambition without realism had sunk reforms before. We determined not to repeat those mistakes. The lawyer's career shifted with the work. In 2014, she left private practice for a law school clinic that partnered with our nonprofit. She taught courses on estate evidence and published a concise article, later cited by judges and students, on documentary indicators of economic coercion. Her syllabus asked students to spot telltales, last-minute changes, shaky signatures, witnesses who appeared only because they were convenient. She taught them to build timelines, a visit, a withdrawal, an unaccompanied notarization. Those timelines pointed not at single acts but at patterns. Her students clerked in courts and staffed clinics. They carried the forensic lens into county probate offices that had previously accepted paperwork at face value. Pushback persisted. Editorial pages continued to warn about slippery slopes and the erosion of testamentary freedom. Opponents argued that narrow protections would metastasize into unreasonable interference. We countered with plain language implementation manuals for clerks, showing how to spot red flags without inviting paranoia. We emphasized training over tribunals and practical tools over ideology. The work carried moral complexities into my private life. Paper and statutes could alter procedures at the probate desk, but they could not, on their own, change a mother's habit of fear or a child's memory of exclusion. My mother's repair was halting and uneven. Legal protections provided scaffolding, but the daily labor of showing up, setting boundaries, and refusing to let old cruelties define ordinary family life remained the real work. Some wrenching moments were private. In the winter of 2017, as snow blanketed the neighborhood, my mother called from her kitchen. She had found in a shoebox of unsent letters a cramped apology she had written long ago but never mailed. The letter was messy, full of half-formed defenses and the kind of remonstrance people write when they attempt amends without fully comprehending the harm, but it was also an acknowledgement. For the first time since the codicil entered our lives, there was a document that was not a clause dictating terms but an act of confession acknowledging cost. I kept that apology with the codicil. Both live folded together now, one a talisman of harm, the other a small, imperfect bridge toward repair. Keeping them side by side is not contradiction. It is recognition that people who harm are often frightened, compromised humans whose choices have ripple effects. That recognition does not excuse harm or deny responsibility. It only locates the act in a context where prevention can begin. By 2020, the project had settled into a rhythm of quiet persistence. The clinic did not rent a ballroom or issue glossy reports. For the 10th anniversary of March 12, 2010, we convened in a community center that smelled faintly of old coffee and fried dough. The lawyer who had first shown me the clause attended, along with volunteers who learned to photograph brittle pages at odd angles, mothers once accused of manipulating estates, fathers who had funded defenses in rural counties, and case managers whose overtime roughened hands had become instruments of care. We ate inexpensive sheet cake. People told stories that were both punishing and necessary. My child, then a teenager, stood at the back and watched people they had previously known only as abstract names in emails. Later, they asked me whether I regretted making the fight public. I thought of the folded paper in my pocket, of the child kept in school because a court clerk asked one more question, of the young person who received counseling that altered a life's arc. I said simply no. Not if it means someone else doesn't have to be punished to satisfy a clause. Not all reforms held. After some veteran clerks retired in 2022, a few counties slipped back toward complacency. Staff turnover and institutional forgetfulness are constant adversaries. Some judges resisted the shift. Old assumptions about family privacy are stubborn. We kept doing the unglamorous work, continuing education seminars, revised tip sheets for clerks, outreach to law schools so new attorneys would learn coercion indicators. We translated court decisions into plain language guides for social workers. We refined a protocol for emergency fund petitions, who to call, what evidence to present, what forms to use. We kept teaching volunteers how to photograph documents, how to create logs that would stand up in court, and how to handle a family's embarrassment with dignity. Private victories multiplied quietly. In 2019, a woman in her early 40s called us, exhausted from caregiving, named in a codicil that conditioned her staying in her childhood home on whether she remarried. We helped file an objection using our forensic framework, patterns of isolation, unexamined witnesses, bank withdrawals routed to a beneficiary. The court granted temporary relief, allowing her to remain in the home while the challenge proceeded. Months later, she sent a short, overwhelmed note. The relief had kept her from being homeless. That note, less elegant than any op-ed, was proof of what modest tools could accomplish. People asked whether I wanted revenge. I asked myself that question many times. My answer is blunt. Revenge compresses life into a single vindictive moment that leaves nothing left to heal. I wanted repair and prevention. I wanted systems that asked different questions so 11-year-olds would stop asking whether they had been written out of existence. I wanted a world where a child could grow up knowing that adults owed them care beyond the line items of a will. The lawyer taught students to look for patterns because lives are hidden in small details. She trained them to build timelines that read like brittle family histories, a visit, a withdrawal, a notarization. Those timelines, presented plainly to a court, are often more persuasive than rhetoric. When we designed clerk training modules together, she insisted on practical drills: how to ask a question without sounding accusatory, how to identify witnesses related to beneficiaries, how to get a hearing scheduled quickly when a child's schooling is at risk. These modest changes transformed probate offices from custodians of form into points of intervention. Outside courtrooms, the work seeped into broader cultural conversation. Beginning in 2017 and increasing through 2020, religious leaders framed stewardship in moral terms beyond asset maximization. School counselors learned to recognize when housing instability had roots in inheritance disputes. Housing advocates noted overlaps between contested estates and eviction cycles. Little by little, the conversation shifted from a narrow legal debate to a broader public discussion about obligations owed to dependents at the end of life. There were moral dilemmas at every turn. Intervening sometimes set elder autonomy against child safety. We encountered elders whose choices were clear and informed, and elders whose decisions were compromised but sincerely held. Our statutes tried to balance deference to autonomy with protections against exploitation. We wrote in procedural safeguards, hearings with clear notice, access to counsel, and pathways for restoration of control if a court determined an elder competent. We aimed for interventions that were minimal, reversible, and respectful. I remember a judge in 2021 who reversed a summary acceptance after our clerk connected bank withdrawals to a beneficiary witness. The order quoted timing and lack of independent witnesses. It was technical, yet it changed the life of a child who then received medical care after months of denial. I also remember a small procedural change a clerk implemented in 2016, an extra intake question on estate forms, Are any dependents' access to housing or funds conditioned on a will? That made flagging routine and prevented harm before it grew. Those small procedural additions, repeated across counties and years, are how practice changes. Those who sought to profit from these arrangements taught me hard lessons. Some did so with charm and manners, others used blunt coercion. Professionals sometimes treated paperwork as ritual rather than evidentiary artifacts to be questioned. That machinery taught me humility. Law cannot cure everything. Prevention requires community work. Cultures that teach people how to read documents and how to read people. There were nights when the cost of advocacy felt impossible. There were children we could not reach, evidence lost to time, relatives refusing to speak, elders denying coercion even when patterns were obvious. Those failures reminded us why persistence mattered. They taught us that law must be practiced with humility and accompanied by services. Law creates boundaries and incentives. Community changes expectations. The combination is what shifts outcomes. The lawyer lived a life of quiet, steady influence. She declined press attention, preferring slow work, teaching, writing, mentoring. At small conferences she redirected praise to students, clerks who asked the right questions, and social workers who testified. She insisted legal protections be paired with supports. Protections without services can relocate harm rather than cure it. Her career became a study in modest institutionalism, forms revised, training modules distributed, clinics sustained. My mother lived long enough to see some of these changes. Aging did not undo her fears, but it opened narrow windows for different conversations. The apology she had written and never mailed contrasted sharply with the codicil, which had once spoken like a lock. Both documents live in my pocket, one proof, one plea. I learned to hold truth and mercy together. Disclosure can be an act of justice, repair can be humble and slow. They are not opposites. There are many modest victories that do not make headlines but change the arithmetic of daily life. A teenager kept in school because bus fare and counseling were covered, a probate clerk who no longer accepts a witness's neutrality at face value, a judge who orders an evidentiary hearing after a seminar on coercion dynamics. These are technical acts with ordinary effects. A child keeps an appointment, a roof stays above a head, a therapy session happens. I teach my child that dignity can outlast dispossession and that truth, messy and incomplete, remains powerful. In 2023, a clerk emailed me a photograph of the original codicil. She had found it in a dusty box during an inventory and was struck by its smallness, the way a few sentences could conduct such harm. I told her to preserve it as evidence and to flag any immediate risks to dependents. She replied that her office had added the extra intake question. That one procedural addition is emblematic. A single question at the right time can prevent a cascade of harm. We continue to teach, to testify, to revise training modules, and to lobby quietly for small procedural changes implementable at the clerk level. We host community meetings where people can ask awkward questions and get practical answers. We accept that culture shifts slowly, and that law without services is blunt. We also accept that law can create openings where none existed. The statutes and protocols we built in the 2010s and the local practices that have spread since are not final answers. They are a beginning that requires continued vigilance. When I take the folded page out, I examine its creases and marginal notations. I see the jagged scroll that once pretended to be consent. I think of the lawyer who showed it to me and, with steady, unsensational determination, taught me how to turn private grief into public tools. I think of volunteers who learned to photograph brittle pages, of clerks who added one line to intake forms, and of young case managers who used a template memo to prevent homelessness. I think of my child who learned that dignity can outlast dispossession. I think of my mother's apology, small, defensible, human. I think of systems changed by inches and how those inches can keep someone alive. If this story has one sentence of moral clarity, it is this: disclosure and repair are slow, practical, and neither triumphalist nor fatalistic. We read paper as if it were flesh because that is where people's lives are written. We teach others how to read. We make small procedural changes that, over years, alter how institutions respond to crisis. We do not expect perfection, only persistence. We are more interested in the quiet ways a child is kept in school or a therapy appointment paid for than in applause. The folded page remains with me as a reminder of two fidelities: fidelity to truth and fidelity to the messy work of human repair. They are not opposites. Records, brittle and bureaucratic, can be tender. They can be instruments of safety and, in other hands, instruments of harm. The choice lies in how we steward them. Years from now, if another child never stands on a painted stoop at 11 and asks if they have been punished to satisfy a clause, I will know the nights spent filing, fundraising, and retelling were worth it. The inheritance I want to leave is not a property or a provision, but a system that refuses to let children be footnotes. That, finally, is what the folded paper taught me. The past can be read, and from reading changed. The past can be read, and from reading changed. That conviction carried forward into the next phase of work, a phase that began in small acts and, by calendar years, acquired a pattern you could point to. In 2024, we began to shift from ad hoc procedural changes toward durable institutional reform. The lawyer I had learned from, who had always preferred classrooms to cameras, agreed to convene a weekend working group in March. She invited clerks, probate judges, social workers, school counselors, and a handful of legislatively minded public defenders. The meeting was quiet, held in a municipal building that smelled of coffee and paper, but it mattered because it was the first time people who controlled different levers sat in the same room with the explicit goal of drafting implementable model language. The product of that weekend was deliberately modest: a model intake addendum for clerks, a short judicial bench memo explaining when to convert a summary acceptance into an evidentiary hearing, and a template for emergency interim relief when a dependent's housing or schooling was immediately at risk. Those documents found their first homes not in state capitals but in county vaults. In June 2024, a mid-sized county in the Midwest adopted the intake addendum as an administrative rule. In the summer, a probate chief from a coastal county called to ask whether they could pilot the bench memo in a single division. By September they had. The pattern was incremental. One jurisdiction adopted a form, another asked for a tweak. Clerks told us the changes were affordable. Judges told us the memos reduced long preliminary hearings by clarifying the triggers for evidence. Social workers told us the templates made their testimony more consequential because clerks were now collecting the right preliminary flags. We tracked these adoptions because counting adoption matters. Without numbers, discipline becomes impressionistic. In a June 2024 report that our volunteer research team circulated among attendees, we documented 28 jurisdictions using some variant of the intake question and 10 judicial divisions employing the bench memo. Those figures do not capture the human detail: an adolescent who kept a scholarship because counsel could show the judge a conditional codicil, a grandmother allowed to remain in her home because a clerk flagged withdrawals that suggested undue influence. But numbers helped advocates say to county administrators, "You are not alone, this is not radical." In late 2024, the lawyer wrote a short field manual, not for journalists but for the people who would actually have to do the work. The manual, titled in internal memos as the Probate Toolkit, was 44 pages and deliberately non-glossy. It contained sample questions for intake interviews, a checklist for identifying beneficiary-witness relationships, and a primer on basic financial forensics that non-experts could use to spot anomalies in bank statements. She insisted that the manual be pragmatic: no theoretical treatises, no long footnoted histories, just forms and scripts. We distributed 1,000 copies to clerks' offices and legal aid clinics. A quiet effect followed. Clerks began returning fewer "we didn't know" answers when advocates asked why a harmful codicil had slipped through. At the same time, there were challenges. In the winter of 2024, a handful of estate planning professionals pushed back. They argued that added layers of inquiry risked paternalism and would burden clients in their last years with undue scrutiny. They framed their objections in terms of autonomy and efficiency. Those critiques forced us to sharpen the balance we had been trying to achieve since 2016: protect elders from exploitation while preserving deference to competent adult choices. We responded with procedural safeguards. By February 2025, our model rules included explicit steps for rapid competency screenings with access to independent counsel and a mechanism for temporary non-coercive supports, transportation to a bank, a meeting with a neutral financial counselor, so that the choice to change a will could be a fully informed one, not a product of isolation. The policy conversation moved beyond municipal offices. In spring 2025, a coalition led by a coalition of probate clerks, a state legal aid network, and a small non-profit I helped advise drafted model legislation for the state legislature. The bill did not seek to rewrite wills. It proposed two narrow mandates. 1. That clerks collect and transmit to judges a small set of risk indicators when a will or codicil is filed, and 2. That courts have a statutory ability to issue short-term administrative stays where those indicators suggest a dependent's immediate jeopardy. We were careful with language. The bill required that the indicators be non-determinative and that the elder receive notice and counsel. It required expedited hearings, not a presumption of incapacity. The bill's sponsors emphasized process, transparency, notice, and time. The bill's sponsors faced a familiar legislative reality in 2025. Early enthusiastic endorsement in committee, amplified concern from some probate bar lobbyists, and the inevitable lobbying that accompanies any change to long-standing practice. What helped was the human testimony we brought. The woman from 2019, whose temporary relief had kept her from being homeless, agreed to testify under promise of anonymity. Her short written statement about remaining in her childhood home until she stabilized carried more weight in a hearing room than any op-ed. Those testimonies, paired with the clerk who had found the codicil in 2023 and the judge who reversed a summary acceptance in 2021, told a story that was both particular and systemic. The legislature passed a variant of the bill in November 2025. It was not sweeping. The final bill required pilot programs in 5 counties and mandated a 1-year evaluation. It preserved elder autonomy by explicitly stating that nothing in the law coerced an adult's testamentary freedom. What it did, quite simply, was create a mechanism for early detection and temporary relief. Implementation began in January 2026 with training sessions for clerks and judges in the 5 pilot counties. The training was practical: how to read a ledger, how to ask a family member for documentation without making accusations, how to order an expedited hearing when a school enrollment report suggested a child was at imminent risk. By early 2026, stories returned. In March, a pilot county reported its first use of the new administrative stay. A teenager's dorm housing remained intact because a clerk had noticed a codicil that cut off the child's access to a trust unless a beneficiary consented. The judge ordered a hearing. The elder appeared with counsel. After a briefer evidentiary process than would once have been thought necessary, an arrangement was reached that preserved the elder's dignity and the child's housing. The local paper wrote a modest piece that quoted the clerk and the judge. The lawyer refused to be photographed. She asked that the coverage lift up the patchwork of services required: counseling, housing supports, and guardianship alternatives if needed. Progress, of course, did not mean that the work was easy or that every story ended well. We still lost cases where evidence had been destroyed, where witnesses vanished, where courts were backlogged and could not schedule timely hearings. In May 2026, a case from a rural county hit national notice when a protective arrangement meant to preserve an elder's autonomy instead resulted in complicated family conflict. We scrubbed our processes, refined our intake forms, and added language requiring better notice to potential dependents before settlements. Those iterations are why the lawyer liked small experiments. Failures taught us faster than triumphs. The cultural shifts that began in 2017 continued to deepen. By 2026, religious institutions had begun to publish stewardship materials that framed end-of-life decisions as not only fiscal choices but moral commitments to dependents. School districts increasingly trained counselors to ask whether housing instability had roots in estate disputes. Housing advocates partnered with probate clinics to ensure that orders from courts translated into practical support: rent vouchers, school transportation, emergency counseling. These linkages mattered because law without services merely relocated harm. Implementation required budgets. In late 2025, a small federal grant program awarded seed money to 5 pilot partnerships linking courts to housing agencies. That funding helped bridge the gap between judicial orders and on-the-ground relief. My own life continued in parallel, not as a narrative of victory but as a ledger of small obligations. I remained involved in training, often returning to the municipal building where that March 2024 working group met. I taught modules on how to translate a thin line of handwriting into questions a judge could understand. I continued to hold the folded page the lawyer had once shown me, sometimes in a drawer, sometimes in a pocket, and I used it in workshops as an object lesson about material evidence. I also parented, teaching my child that words on a page can have weight, and that dignity can be a practice rather than an abstraction. My mother and I developed a guarded rhythm. In 2024, we spoke infrequently but more candidly than we had in the first decade after she kicked me out. She had not been keen to publicize anything and still resisted scrutiny. She remained fearful that transparency would cost her more autonomy. Yet she had written an apology I had kept. That apology, old, tentative, imperfect, was not a legal instrument but a human artifact. In late 2025 we sat across from one another and read the apology aloud, with neither theatrics nor absolution. She explained, in a voice that faltered, how fear had shaped decisions, how shame had compressed her world. I did not forgive as a legal act. I learned how to carry both the apology and the codicil in the same pocket of my jacket. That is the messy form repair often takes: parallel documents, parallel truths. The lawyer declined honors but accepted invitations to teach. In 2025 she began a small annual seminar for new clerks and judges, capped at 50 to preserve conversation. Her pedagogy remained hands-on. She often began sessions by handing out a brittle codicil, paginaed, typed, a few lines scrawled in a margin, and asked trainees to tell the story from the artifacts alone. She wanted them to learn humility. The paper might tell many stories. Their job was to translate it into protection without assuming villainy or erasing agency. There were broader research projects underway by 2026. A university clinic we partnered with had started to track outcomes from pilot programs, measures of school retention, housing stability, and the incidence of emergency guardianship. Early results were encouraging but provisional. The evaluation team emphasized mixed outcomes and called for patience. Still, having empirical work helped advocates argue for sustained funding rather than one-off pilot grants. Evidence, like a folded page, can be read to reveal patterns. Those patterns can be persuasive. I will not pretend that the work is finished. There are guardianship systems that still need reform. There are private actors who test the edges of statutes. There are families who dispute every intervention. But the arc of the last decade suggests something practical. That small, well-designed procedural safeguards, informed by community services and grounded in a respect for autonomy, can meaningfully reduce harm. The years between 2016 and 2026 are not a tidy narrative of triumph. They are a history of incrementalism, of pilots, of legal drafting done by people who understood both the power and limits of paper. Looking ahead, the work has three obvious axes. One is continued training and diffusion. The intake question and bench memos must be refined and taught to new cohorts of clerks and judges. The second is service integration. Courts must have reliable pathways to housing vouchers, school liaison services, and financial counselors. The third is research. Without longitudinal data, policy conversations revert to anecdote. We have begun to address all three, but none will be completed in a single legislative session or a single grant cycle. I carry the folded page as both personal relic and civic artifact. It reminds me that histories of harm are often written in small, legible strokes: a name, a date, a clause. It also reminds me that histories of repair are built the same way: one intake question, one training module, one expedited hearing after another. In the end, the promise I want to keep is not to invert the ledger of my childhood into a ledger of vengeance, but to transform the institutions that let such harm occur, so that another 11-year-old will not have to read their life in margins and wonder whether they matter. That work continues, measured in incremental laws, in the quiet changes of clerk rooms, and in the slow unfolding of community supports, and it will require vigilance for years to come. The pilot years stretched into a second phase with the stubborn, incremental logic of most institutional reforms. In the first half of 2026 we consolidated training materials and uploaded case templates to an intranet that clerks in other counties could request. By August 2026 the university evaluation team had completed its first interim report, using enrollment rolls, shelter intake data, and a matched set of comparison counties. They documented signs that the administrative stays and expedited hearings were doing exactly what design intended, preventing immediate displacement while not unduly intruding on testamentary decision-making. The report was careful, almost anxious, in its wording: early signs of improved school retention and fewer emergency shelter entries among dependent adults and minors where clerks had flagged risk indicators, a small number of contested hearings that required full evidentiary procedures, and widespread praise for the process language that forced notice and counsel. The cautious phraseology in that August 2026 report mattered politically. It let advocates argue for the model's expansion without claiming victory, and it gave critics something to point at when they wanted to slow the spread. In October 2026, our working group convened a public symposium, the auditorium filled with clerks wearing county nameplates, juvenile advocates, housing caseworkers, and several people who had once testified under promise of anonymity. The woman who had written her brief statement in 2019, who had kept a job, held on to the home where she had lived until the trust dispute was resolved, and returned to school, sat in the back and listened. She did not speak that day, but her presence signaled that what began as discrete harms were now legible as patterns. The political terrain grew more complicated in 2027. A coalition of probate attorneys in neighboring counties advanced a ballot initiative in the fall that would have limited the new administrative stays to circumstances of explicit judicial conservatorship. The initiative reflected a genuine professional anxiety, concerns about due process, evidentiary burdens, and the specter of mission creep, but it also framed reform as a zero-sum choice between autonomy and protection. We responded with a targeted communications campaign that emphasized process rather than paternalism. We highlighted the training modules, the counsel requirement, and the statutory prohibitions against using risk indicators as determinative evidence of incapacity. We also highlighted stories: the woman from 2019, the teen whose dorm housing was preserved in March 2026, because lawmakers and voters do not respond to clauses as readily as they do to faces. The ballot measure was defeated in November 2027. The margin was narrower than anyone hoped. The victory did not feel like triumph so much as relief. That winter, buoyed and chastened in equal measure, the legislature expanded the pilot program to 15 counties and increased funding for the court-linked housing vouchers that had become the tightest choke point. The federal seed grant from late 2025 had helped start the bridge between judicial orders and services. The 2027 appropriation made that bridge wider and more durable. In April 2028, the university team published its first peer-reviewed article in a legal journal. It documented a small but statistically significant improvement in housing stability among dependents for 6 months following an administrative stay, which correlated with better school attendance for minor dependents and fewer emergency petitions for guardianship. The article did not claim to have solved intergenerational precarity. It offered, instead, a set of replicable procedures and a sober accounting of where the policy faltered. The authors recommended longitudinal panels and cautioned against treating procedural safeguards as substitutes for public benefits. Those recommendations shaped the next phase of work. Between 2028 and 2033, related policy strands developed. 1. The technical, improving data systems so clerks could flag filings without compromising privacy. 2. The services, creating guaranteed short-term housing and school liaison funding streams in the budgets of partner counties. 3. The legal, refining statutes to guard against overbreadth and to create appellate pathways for rapidly contested stays. The technical strand was the most contentious. A small vendor proposed an algorithmic triage tool in late 2028 that would surface filings with certain combinations of risk indicators. Privacy advocates worried about automated flags, while practitioners liked anything that reduced clerical error. After public hearings, the working group adopted a human-in-the-loop requirement. Algorithms could assist but not adjudicate. Clerks were trained to view any automated suggestions as prompts for human review, preserving judgment over automation. The services work had its own politics. Municipal budgets are finite, and emergency housing is a visible, expensive line item. In 2029, 2 counties in the pilot network formed a pooled funding consortium, combining state housing vouchers, philanthropic capital, and local contributions to create a rapid response housing fund. That fund functioned like an emergency line of credit. Judges could issue vouchers tied to a 30 to 90-day period while social workers implemented stabilization plans. The pooled fund reduced the wait time between a judicial order and an actual roof over someone's head from weeks to days in many cases. Those practical reductions changed litigants' expectations and judges' minds. The legal strand required vigilance. By 2030, there were several published appellate decisions interpreting the statute's notice and counsel provisions. One published opinion from a mid-level appellate court narrowed the definition of what constituted immediate jeopardy, and the legislature responded in the 2031 session with clarifying language that emphasized foreseeable, imminent harm while tightening evidentiary thresholds for stays longer than 45 days. The back and forth taught a consistent lesson. Procedural innovation thrives only if it is legally durable and politically legible, and durability requires legislators who understand both the law's limits and its humane intent. My own life kept moving alongside these institutional changes. Parenting does that. It demands attention to particularities. My child was 7 in 2026. By 2029 they were in middle school and assigned a project on local civic institutions. One evening in spring 2029 we sat at the kitchen table and my child asked, in that blunt way older children have, why I cared so much about probate clerks. I handed them the folded page, carefully, because the paper has become frayed, and read aloud the codicil the lawyer had once shown me. The lines in the margin that had once been threats felt, when read together with years of policy work, less like absolutes and more like the beginning of a public conversation. My child, at 11, asked whether the person named as a beneficiary had known about the dependent who had been cut off. We talked about fear, about secrecy, and about the choices estates make that ripple through other people's lives. That domestic conversation, equal parts pedagogy and confession, felt in its small way like part of the larger civic repair. My mother's health and our rhythm withered and waxed. In March 2028 she had a minor stroke. I flew to her bedside and we do not pretend we were anything other than awkward, which is a kind of honesty. Her apologies, tentative and imperfect, had been read and reread in late 2025. After the stroke she offered more explanation than apology, sometimes blaming the world and sometimes herself. We met with the lawyer once in June 2028 because my mother wanted to arrange something she could live with, a trustee who would consult with family members without surrendering her autonomy. That arrangement was not reconciliation so much as a pragmatic settlement between two people who had long ago traded youth for worry. The lawyer, who by then lectured at institutes across the region and continued to refuse honors she felt would be performative, helped broker a neutral arrangement. A limited trust amendment that protected certain dependents' housing rights without imposing sweeping financial instructions. It was a compromise crafted by someone who had come to believe that law works best when it binds hands against harm without taking away the dignity of choice. The national landscape altered in small increments. States with similar demographic shifts, rising numbers of children and young adults dependent on familial housing as local rents rose, began to pilot versions of the statute between 2029 and 2032. Some mirrored our approach, others added more expansive mandatory reporting requirements that raised constitutional questions. In 2031, a consortium of national nonprofits convened a conference at which our model was presented as a case study in procedural minimalism, using courts' administrative powers for short-term stabilization rather than long-term guardianship. International delegations from 3 countries visited in 2032 to study the pilot architecture. They were surprised by how modest reforms could alter the flows into homelessness prevention systems. There were losses along the way. A family in late 2028 lost crucial documentation when a house fire destroyed a ledger, and the lack of paper evidence prolonged a dispute into full guardianship proceedings. The failure exposed the fragility of systems still dependent on physical artifacts. In 2030, a judge in a larger county refused to issue a stay without an evidentiary hearing. The dependent lost housing while the case limped through protracted discovery. These setbacks led the working group to create redundancy, digital affidavit systems, secure scanning protocols, and pro bono forensic assistance for destroyed records. Incremental fixes can feel pedestrian when lives are at stake, but they matter because they reduce the number of times policy fails in precisely the way that harms people. Research matured. By December 2032, the University Clinic published a longitudinal study tracking outcomes across the original 5 pilot counties and the dozen that later adopted the model. The study's headline finding was modest but significant. Where expedited stays were used and linked to housing supports, the incidence of poverty-triggered displacement among dependents declined over a 2-year observation window. The authors were careful to note heterogeneity. Outcomes were strongest where counties coupled judicial orders with coordinated social services. The study's recommendation, that courts be funded to interface with service systems, was echoed in a 2033 federal guidance memorandum urging jurisdictions that received public housing funds to consider court-linked stabilization strategies. The lawyer remained a steady, if private, figure. She continued teaching the small seminars she valued, By 2029 the roster filled quickly, and in 2031 she published a short practitioner's manual that synthesized case law, bench questions, and intake templates. She resisted celebrity and never sought public office. She told me once, in a hallway at a conference in early 2030, that her work felt less like heroic intervention and more like a long apprenticeship in humility. She repeated that she had never wanted to erase agency. She had wanted mechanisms that kept people afloat until longer-term solutions could take root. By 2033 my role shifted. I began advising a national foundation that wanted to scale the model beyond county lines. Scaling raised familiar anxieties. Standardization can calcify local innovations, and what works in one county may not in another. We spent the year designing an implementation playbook that emphasized local adaptation, that reserved space for community organizations to tailor services, and that required continuous evaluation. The playbook stressed 3 pillars we already knew by habit: intake and training, service integration, and measurement. It was less a blueprint than a map of what to guard against. On the personal front, my child entered high school in fall 2033 and asked, as teenagers do, sharper questions about justice and memory. We attended a city council meeting in October where a proposed zoning change threatened to displace several long-term residents. The debate was raw, about markets and values and who belonged where. Afterwards, over rice, my child asked whether the scale of the problem made our narrow legal work insufficient. I told them the truth I'd been learning for years. Law can prevent an acute harm. It cannot by itself create the kind of affordable housing a society needs to be just. That caveat did not make the law less important. On the contrary, it clarified the work's place in a larger architecture of change. The next legislative cycle in our state was scheduled for early 2034. We had a docket of amendments we wanted: clarifications on digital filings, protections for particularly vulnerable dependents like those with disabilities, and an appropriation for long-term housing transitions that would build on the emergency vouchers. Opposition was predictable and persistent. Some argued that the statute made judges into welfare administrators. Others, that it risked chilling testamentary freedom. We drafted, lobbied, and taught. I found myself returning to a line I had used since 2017, which was not an argument about rights so much as a description of effects. Small procedural changes can stop acute harms and buy time for deeper policy solutions to emerge. When I look back to the night the lawyer first showed me that folded page, the page she had uncovered 2 decades after my mother had closed the door on my 11-year-old life, I still feel a blend of anger and gratitude. Anger at the decision that forced my childhood into margins. Gratitude for the fact that a piece of paper could be read as evidence of a hidden displacement and then used to argue for a different institutional response. The arc from that private revelation to a public set of practices is not linear, and it is not complete. There will always be families who game systems. There will always be bureaucratic inertia and budget shortfalls. But the history from 2016 to 2033 suggests one persistent truth: small, careful procedures, when tethered to services and evaluated honestly, can reduce the number of times childhoods are written out in the margins of legal documents. We carry the folded page forward because artifacts anchor memory and law. They remind us that policy originates in concrete harms. The work ahead, funding transitions into stable housing, expanding training to new clerks and judges, and building longitudinal research, is as much civic as professional. It will require patience, continued humility, and the willingness to iterate when programs fail. I do not expect a single legislative session to finish what 2 decades of quiet revelation began, but I also do not imagine returning to a world where hidden codicils and silent exclusions go unremarked. That is the promise we keep working toward: one expedited hearing and one housing voucher at a time. Early in 2034 the statute amendments we had labored over for 3 years reached the legislature's calendar. We filed testimony in January, coordinated witnesses in February, and in March I found myself back in a committee room that smelled of coffee and old paint, carrying the same frayed page I had once folded into my pocket. The docket that session was particular: clarifications on digital filings that would prevent the kind of paperless gaps that had torpedoed a family in 2028, explicit protections for dependents with disabling conditions, and a modest appropriation intended to underwrite transitional housing vouchers for jurisdictions that used the expedited stay process. Opposition was as predictable as the calendar. editorials in statewide papers resurrected the familiar charge that judges would become welfare administrators, while some probate attorneys argued the measure risked a chilling effect on testamentary freedom. Our answer was procedural and empirical. Show us the harms courts were already asked to manage, and then show how small judicial tools could reduce the number of times childhoods were excised from paperwork. The hearing on April 12, 2034, ended up being less theatrical than the commentators predicted. Testimony came from a social worker from County B who had used an expedited stay in 2031 and then partnered a family with a housing navigator. She described a mother who, 2 weeks later, found stable work and the dependent who would otherwise have been displaced continuing in the same home. The University Clinic's December 2032 study was cited repeatedly. Lawmakers who had been skeptical were impressed by the 2-year observation window that showed reductions in poverty-triggered displacement where stays were paired with services. I spoke last, not as an expert but as someone whose childhood had been written into a margin. I placed the folded page on the table and read aloud the codicil that had been tucked into an estate file. The room stayed quiet in the way rooms stay when the administrative and the intimate collide. The bill that emerged from that cycle, passed in June 2034 after a series of amendments, was not the sweeping reform some advocates had wanted. The appropriation for housing transitions was smaller than we had requested and tied to matched local funding. The digital filing clarifications were adopted only for counties above a certain population threshold, and the strongest protections for dependents with disabilities were left to rulemaking rather than statute. The pragmatic in me had learned to accept incremental wins. The law that passed institutionalized the idea that a temporary judicial stay could be deployed quickly and that clerks would receive training on intake and documentation, while funding would be available for pilot transitions. Implementation work began in earnest that summer. From 2034 through 2036, the foundation I advised shifted from design into delivery. We used the playbook to certify trainers, to seed technology that supported secure scanning and authenticated digital affidavits, and to underwrite pro bono forensic assistance for families whose physical records had been lost. In the winter of 2035, we convened a regional training that drew clerk magistrates from counties that had never had such an intake protocol. The sessions were as much about listening as about teaching, because local actors knew where the brittle spots would be. Where the 2028 house fire had exposed dependence on paper, the new systems created redundancy. Where the 2030 judge's refusal had demonstrated the danger of protracted discovery, the playbook encouraged early evidentiary ladders and coordinated service linkages to prevent displacement while litigation moved forward. Not all jurisdictions moved at the same pace. Between 2034 and 2036, the model spread from the original 5 pilot counties and the dozen that had adopted early, to several dozen counties across 3 neighboring states. Some localities added reporting requirements that went beyond our recommendations. Others created cross-agency workgroups that paired clerks with housing authorities and child welfare liaisons. The result was heterogeneity. Some places prioritized speed and minimal evidentiary thresholds, others emphasized documentation and oversight, but the underlying architecture remained the same, a compact that treated the court as a stopgap, not a long-term substitute for social investments. The legal landscape also continued to evolve. In late 2036, a coalition of guardianship advocates filed a state-level challenge arguing that the expedited stays unduly interfered with testamentary freedom and that the statutes had not provided sufficient procedural safeguards. The case moved through the appellate process in 2037, and in a narrowly reasoned opinion the state appellate court upheld the stays, emphasizing the statute's temporal limits and the requirement that stays be accompanied by an immediate plan for social services. The opinion was careful to thread constitutional needles. It did not declare a new power for judges but rather recognized a procedural tool constrained by time and by the need to defer to adult testamentary intent when longer-term decisions were at issue. The decision rippled outward. Some legislatures used it as a template for clarifying statutory language, while others sought tighter safeguards. The lawyer who had first showed me the folded page filed an amicus brief in the appellate proceedings in which she laid out the institutional design principles she had taught in her seminars: humility, proportionality, and the binding of hands against foreseeable harm. She did so without seeking attention. Her brief was substantial but unadorned, a practitioner's restatement rather than a plea for personal credit. On the home front, things continued to change in ways both predictable and strange. My mother, whose stroke in March 2028 had already reframed our relationship, grew quieter as the decade progressed.